Welcome to the League of Champions webinar series. I guess we're up to number 12 now, I would think, David. We'd like to welcome everybody here. I'm not even going to guess at how many people that we have on here today, but we're up in we're up in the ranges of, we're expecting 60 guests here today. So my name's Dan Fleming. I'm the manager here for NORCAT. We're a nonprofit organization, help support the OHSA, the League of Champions, for health and safety and consulting services here in the GTA and across Ontario. So it's a pleasure to be here today. Today we're going to be speaking on managing workplace risk during the pandemic. We've got the honor to have Norm Keith here today with us. Norm's going to be, welcome Norm. Just a quick welcome. Hello, how are you?
I am good. Are we all good with the audio? Can you hear me?
Yeah, coming through loud and clear. Norm got all dressed up for us today, so so that's good. You're looking awfully sharp for a Christmas tour. We've also got David Frame with us here today. As everybody's familiar, as we go through these webinars, the Zoom webinars, please feel free to look at the bottom of the screen, and you'll see there's a Q&A. Norm's going to be speaking today, speaking on the pandemic and the challenges we're having with from a legal perspective. So please feel free to send some Q&As throughout the webinar. And as the Q&As come up, we'll speak with Norm and discuss some of the questions that we have from all the group. Right? We're also at the bottom, you'll see there, that's good there. And we also have David Frame, Director of stakeholders, I guess it's government relations.
Government relations, yes.
Government relations, big fancy. Yeah, so welcome, David. And I'd like to let David give us a little bit of background about the League of Champions and about where we're going to be going from here to finish off this year 2020. So go ahead, David.
Thanks, Dan. I'd like to thank everybody for joining us for our 12th version of that. Who would have known at the beginning of the year that the League of Champions, which is known for everybody getting together and celebrating safety in person, like the pictures behind Dan and I, would end up being online like this. But here we are. We're going to be coming back again in the new year with a new program. We don't have a lot of details to give you today, but stay tuned. In the new year, you'll be hearing more from us. We have no more webinars scheduled at this time, but we will be coming forward in the new year. So for the time being, we are asking you to come to us. Let us know what you want to hear from us about. Mental health is one that we're looking at right now. It's going to be a long, possibly difficult winter with some of the restrictions we're working under. And we'd like to continue to support you in your workplaces. So that's one we're looking at. But any other ideas and needs you have, please get back to Judith and I, and we'll try to respond. Norm is up today. This is actually Norm's third appearance on these webinars. Can you believe that? So Norm's the most popular by far, I guess. I don't know if anybody else has had two. But anyways, we've given Norm his own show today. So that's a first. We've always had multiple speakers, and today, Norm, the floor is yours. So we're looking forward to detailed presentation, and it's an important issue considering the changes that have gone on during the pandemic. So I'd like to wish everybody a happy Christmas, happy holiday, happy New Year. And back to you, Dan, for the start of the webinar.
Awesome, David, thank you. Yeah, I think you did mention that the webinar is being recorded. So we'll also have copies of this on the League of Champions website. So please feel free to share that and visit our website. So at this, to no further ado, I'd like to introduce Norm Keith. Norm's a labor and employment lawyer and specializes in wrongful dismissal, health and safety, fiduciary, duties of workers, compensation, advice, and litigation. He advises clients on a broad range of human resources, human rights, and civil rights, and workplace risk management matters. He represents clients in the courts, tribunals, and a broad range of employment litigation, including employment standards, privacy law, competing employees, restrictive covenants, human rights complaints, AODA complaints, safety-related work refusals, appeals in the Ministry of Labor orders, charter applications, and constitutional challenges. And Norm's a trusted advisor to clients in the area contracted negotiations, license agreements, publishing agreements, and collective bargaining. He represents clients in the publishing, visual arts, live theater, production, and film industry. So please welcome Norman. It's great to have you back here again, and I look forward to your presentation. Cheers.
All right. Just confirming, Dan, you can see the presentation on the Zoom slide?
Yeah, but we have it on presenters view. I don't know if you can switch that over to.
All right. Not sure what that means, but I think we should get going.
Okay.
It's all right, Dan.
Just a couple of introductory. Sorry.
Yep, you're good. Yep.
Yeah, it's great.
Okay. Thanks, everybody, both at the Ontario General Contractors Association, the League of Champions, and NORCAT for asking me to come back. You'd think maybe you'd got tired of me, but maybe third time is a charm. So thank you for this opportunity. As a management side labor and employment lawyer for over 30 years, I guess COVID has presented one of the largest and sustained challenges that we at my firm, Faskins, and a lot of clients of our firm have had. From the shutdowns in the frenetic March of 2020 to the continuing uncertainty about what stage, what color, and what activity is lawful or not, the construction industry has a real significant and ongoing challenge. So it's with that challenge, and obviously as a lawyer looking at legal risk, that I'm going to touch upon 4 major areas of legal risk management. So what I hope we do as we go through the 4 sections is to give you some highlights, some guidance, and some assistance in coping with occupational health and safety risk exposure, workers' compensation exposure. And we're going to talk a little bit about the interplay between those two in labor relations, and then also employment law. So a lot of material to cover. After each section, we're going to pause and give a question or two opportunity to the audience. And I want to thank you for joining us on this cold Monday to look at legal risk management for employers in the construction industry during the ongoing pandemic. So the question everybody's asking and that we're asking as well is, how are you doing 10 months and counting in? How does your health and safety compliance look? What about your workers' compensation claims? Are you getting a lot of questionable claims? Are you getting overwhelmed? Are you concerned about how to investigate them? How does your labor relations climate look? There's a lot of activity in unionization going on now for the non-union sector in construction. And there's interesting challenges that both unions and employers have in a labor relations context. And then for non-union management, companies are having to look at right sizing, downsizing, or upsizing. And we're going to talk a little bit about some of the recent developments in employment law that can help you navigate your legal risk there. So I want to pause for a very brief moment. I'm not an epidemiologist. I'm not an employee of the World Health Organization, but I can read. And last night, in finalizing the slides, I put these together. I think we need to keep in mind that this is part, our seminar in Ontario, the construction industry, is part of a larger picture and challenge. So there's been over 70 million COVID claims or COVID positive tests and over 1.5 million deaths. This is a serious worldwide pandemic. In Canada, we have close to 500,000 Canadians who have been infected with the COVID virus and over 13,000 deaths. And although we've done better than many countries, not clearly as well as some. And then in Ontario, where we're focused, we have over 42,000 positive tests and almost 4,000 deaths. So it's a continuing big problem that we need to not pretend is going to go away with the beginning of the vaccination program for lots of reasons, not of which I'll get into, but we're going to be dealing with COVID, I think, for the next year. So let's look at the challenges that we have, where we're at, and how we can manage our legal risk better. So when we talk about legal risk management at a high level, and this is a whole seminar, this one slide in itself is, what are your goals when you want to manage your legal risk? Well, I think you want to optimize worker health and safety, number one. You want to ensure legal compliance to reduce legal risk, number two. but you can't also lose track of your third goal, which is to maximize and continue your business activity. However, as we've seen in some of the early days of COVID, governments have a lot of power to affect your business. Under the Emergency Management and Civil Protection Act, they can shut you down or allow you to operate. Public health authorities that we didn't really pay much attention to in the construction sector now have a great deal of authority to set guidance and have set actual regulations are going to take you to that you must follow or you're breaking the law. There's the overarching obligations of the Occupational Health and Safety Act, but disappointingly and strangely, governments across the country have not provided any regulatory guidance. So this is a challenge that we have to go back to first principles constantly to fine tune and ensure that we're fully compliant, because there is more and more evidence that the Ministry of Labor Training and Skills Development in Ontario is engaging in a more aggressive campaign of prosecution if one doesn't comply with the general duty clauses for both employers and supervisors. And a general contractor or constructor would also be considered an employer. Then, of course, we've got the challenges of managing claims. Are they legitimate or not? How do we prove if it's a COVID claim or not? We're going to talk about that, and then we're going to deal with labor and employment law a little bit further down. So let's talk about the health and safety framework. Now, normally we just start talking about the Occupational Health and Safety Act, but we start earlier because we have to look at the Health Protection and Promotion Act, because through the Ministry of Health and regional public health units, they set the public health standards and they set the details that will inform Ministry of Labor and by law enforcement officers. So the 5 bullets we have under guidance about stopping the spread really haven't changed that much since March, but they're to be kept in mind not only as a good idea, but also as a legal standard that if you don't comply with, you're going to have problems with health and safety compliance. Now, interestingly, a little over a month ago now, we had quite a change in the approach that public health, both from the Ministry of Health and health units, took in terms of rejigging the whole idea. So what we're looking at is, in effect, the 5 colors. It actually is modeled on New York State, if you've been tracking what's been going on stateside. And we know that Toronto, for example, is in the gray lockdown stage. Now, that is a public health direction that is somewhat conceptually separate from the right of government to pass a regulation under the Emergency Management and Civil Protection Act to actually shut down an industry, but they work together. So one has to keep this in mind while we're looking at the process that we've talked about. In terms of the actual law, there are 3 really important rules that are under Regulation 36420, and they come out of the HPPA, not under the Occupational Health and Safety Act, not under the Civil Protection Act. And they are on the slide. So we're going to talk about them because they're really important, because if you don't comply with them, you're offside. First, is your business, is the person responsible for the business operating in compliance with the regulation? If not, we're now seeing public health prosecutions. 2, have you gone through mandatory screening of all workers and essential visitors every day? This is not once a week, it's not once a month, it's every day. Third, there's a minimum of 3 questions, and a lot of employers expand upon them that are listed. I won't read the 3 questions because of the amount of material we have to cover, but if there's any indication of a yes, of a positive, about symptoms, testing positive, traveling outside the country for the 14 days, and close contact with a probable case, an actual or probable case, then you can't allow the worker to come to work. Different employers are going further, and we'll talk about that in a minute, but these are the basics. And if you aren't complying, per se, you're not legally in compliance and therefore might be at risk. So when we step back a little further and say, well, okay, what are the health and safety laws? We know that there's a $1.5 million fine for corporations who don't comply with the Occupational Health and Safety Act, unlike typically the $5,000 fine for non-compliance with a public health order. So these are more serious. How do they connect? Well, quite simply, the general duty clause under section 25(2)H And for supervisors, and this is often overlooked, 25(2)(a), the reasonable precaution is now being looked at by the Ministry of Labor, Training and Skills Development. I'm, for sake of time and breath, going to call them Ministry of Labor still. They say, and have taken the position with a number of our clients, that it is a reasonable precaution to protect workers from hazards to comply with the health and safety standards. So when public health is saying something that you have to do now, you're actually incorporating by reference into 25(2)(h) that standard. So in effect, rather than just an exposure to a $5,000 fine, you could be exposed to $1.5 million fine. And the same for supervisory exposure under 27(2)(a). So keep remembering that COVID is a potential workplace hazard. The skills that safety professionals, that a lot of you in managing your construction projects safely, have to identify, assess, attempt to exclude and eliminate, and if not, then manage the hazard of COVID in the workplace. And that's where, of course, we only have guidance from the various workplace safety associations. We don't have a law saying exactly what you need to do, but you can still be exposed to accountability under 25(2)(h) by either not being in compliance with a public health order or not being in compliance with a generally accepted standard or guidance from, say, the Infrastructure Health and Safety Association. That might not seem fair. It might not seem right that there's no law, no regulation, but yet you can, in effect, incorporate by reference or absorb those standards into the 25(2)(h) requirement. But in a pandemic, you don't want to get to be that test case where you challenge the scope of 25(2)(h) as not including those. Generally, my advice is they will be included in that broad duty. So who has responsibility? Well, this is often a surprise to many clients that officers and directors of the corporation are as accountable as the actual constructor, general contractor, or employer. We know supervisors and workers are not often held accountable through prosecution, but still have duties under the Act. But more and more, we're hearing from the Ministry of Labor that directors and officers of companies who aren't fully compliant may be targeted as well. They, of course, have an exposure to a $100,000 fine or 12 months in jail or both. So we're talking about a pandemic that if you get the virus, although it's not a high probability, there's a risk of death directly or indirectly to somebody you give it to. And so the Ministry of Labor is saying, look, this is serious. Your directors and officers will be held accountable as well as you as an employer from a business point of view. So where do you go then? Well, the Act itself has a requirement that you have a policy to deal with workplace hazards. COVID's a hazard. Where's your policy for COVID-19? Who's in charge of it? What are the roles and responsibilities of the program? Are you doing a question and answer and updating feature to it? And then do you have safe work procedures for access to the job site, checklists to comply with daily, training and record keeping, monitoring of compliance, and ongoing accountability? COVID's not going away in a hurry, and vaccination's coming, but very slowly. So these are key things to keep in mind, especially as numbers continue to be high and troubling in the construction industry as well as the whole province of Ontario. So let's go further about what are best practices. In other words, what is your best practice, and is it meeting industry best practice so that you can argue when you're dealing with an incident, a complaint, an employee who's not compliant, and that is another sort of synonym to the due diligence defense. If you're not meeting industry best practices, it's going to be hard to argue legally that you have the defense of due diligence, okay? So are you both collecting and recording the worker screening questionnaire daily? Now, the next one's a bit controversial, but I'm a fan of it because it provides objective, albeit imperfect, evidence of a potential symptom of COVID. In other words, a fever. So some projects have started and then abandoned this. It's not required by law. It's hard to get anybody in government to commit whether this is a best practice or not, but I believe it is for three reasons. One, it's a backup to the questionnaire. Two, it's objective, not self-declarative. In other words, you're measuring the temperature of somebody coming on to the project. And even if they say they're okay, they may believe it. They may actually be misleading you because they want the paycheck, but it's an objective measure. Now, is body temperature guns for thermometer guns or screening tables or screens that are small and portable, are they perfect? No, but they add an objective measure to the screening process that I like because that's the test the courts look for. They want objective proof of steps taken to keep the hazard, COVID-19 virus, and people carrying it out of the workplace. Simple concept, eliminate or keep the hazard out of the workplace. How do you do that? I think body temperature screening is a good idea. I think the NORCAT people have an excellent demonstration of how they've incorporated that into touchless screening that's been adopted in the mining sector significantly. I think that is a best practice that contractors should look at. Supervisors are key on the job site to your best practices. They've got to go through the return to work checklist for workers. They've got to, as you've developed a safe work procedure from your general policy, make sure workers are complying. Supervisors are key to making sure your due diligence as an employer is being achieved. And that's a lot of pressure on a supervisor, especially when there's a lot of anxiety, a lot of irrational fear and rational fear about COVID. Supervisors should really be equipped to provide support and resources to workers. And if there's non-compliance, I recommend counseling or coaching or encouraging before you go to discipline, although discipline cannot be ruled out, and I'll explain why through a few examples in a minute. So those are some of the best practices, what we're recommending that you and your organization consider in the construction industry. Now, what happens? This question gets asked once a week, if not more, at least people calling me and asking me or emailing me. Well, what do we do? People often don't look at the Occupational Health and Safety Act comprehensively. There actually is a very clear reporting obligation for an occupational disease. COVID, if transmittable at a workplace, transmitted at a workplace, or there's a potential of either, is an occupational disease. So section 52.2, which is quoted on the slide, I won't read it because it's there for you to read, requires the employer, not the constructor, the employer, to report an occupational illness within 4 days to the Ministry of Labor, Training and Skills Development, and also to the Joint Health and Safety Committee. When in doubt, you have to report. What's happening is that sometimes workers or their physicians or sometimes their unions are filing a Form 6 or a Form 8, and then you're finding out that, you know, through the WSIB, and they're notifying public health and they're notifying the Ministry of Labor. So you get a visit from a whole bunch of people or a call with a lot of people on the line saying, you didn't report this under 52.2. Now, I'm not seeing a lot of enforcement of this section yet, but I'm hearing from Ministry of Labor contacts that they are increasingly concerned about cases being hidden, cases not being reported. And if there's anything that gets a court, as well as the Ministry of Labor, upset, it's employers who are trying to hide things that are going on at their job site. So if there's a provable or probable case, and we'll talk about the WSIB reporting in a few minutes, you must report independently to the Ministry of Labor. WSIB, Ministry of Labor, they collaborate more than ever, but they're two separate regulators for two separate purposes, complementary but separate, and there's two separate reporting obligations. Or to put it another way, your Form 7, if it goes into the WSIB, is not notification under 52.2. And if you think it is, you're going to maybe find out the hard way through an enforcement action that it wasn't. Let's talk about a case study that reinforces just occupational health and safety legal risk management. This case does not come out of the construction industry, but it could have. So we've heard a lot this past summer about farm workers and COVID exposure, and there were some deaths, tragically, of farm workers often coming up from Central America and Mexico. In the particular case, a worker filed a complaint with the Ontario Labor Relations Board under section, pardon me, I have a typographical error there. It's not section 61, it's 51. And 51 says that there is a right to be free from reprisal if you raise a safety concern. So the worker had actually complained to the employer about COVID living conditions, that they weren't safe enough, that there wasn't enough physical distancing, that somebody had tested positive, they weren't removed from the dormitories soon enough, and then they also decided, because action wasn't taken, in their opinion, quickly enough, they went to the media. Well, the employer didn't like it. They put pressure on the person to resign. In fact, they said, basically, we're putting you on a plane back to Mexico and we're revoking your work visa. That's a pretty heavy-handed approach. It's kind of like trying to, get rid of the problem by sending them out of the country. Well, the labor board didn't appreciate that. They said that this was a clear violation of the anti-reprisal provisions, and the labor board awarded $25,000 for the worker whose employment was terminated. So the lesson from this is, if you have a complaint, legitimate or not, you need to take it seriously. COVID is a serious pandemic disease. You need to investigate it as best you can. You need to do contact tracing internally. You need to go back to your records of who was saying they were COVID-free and are they, and verify that. Using an outside health agency or a company nurse might be an effective strategy. And then you need to resolve the complaints. And if somebody complains and it turns out that they're just overreacting and they're not malicious in doing so, you can't fire them, you can't let them go. That's a violation of the Occupational Health and Safety Act. So there's legal risk coming out of the Occupational Health and Safety Act for employers for three different ways. One, failing to have the proper plan in place, including safe work procedures. Number two, failing to execute that plan effectively to achieve a best practice or due diligence standard. And then thirdly, it's unfair treatment of workers who raise concerns. We haven't talked at all about the work refusal, Section 43. That was part of what the employer tried to pretend was the failure of the employee to make out the case, but that was dismissed by the board. So you've got workers with the right to refuse to unsafe work. You've got to respect that. You've got an anti-reprisal provision in the Occupational Health and Safety Act that obviously the labor board used to give the $25,000 to the worker for the concern. And you've got the penultimate authority of the Ministry of Labor to lay charges if they feel you're not in compliance, whether or not somebody's seriously adversely affected by COVID. So that's occupational health and safety risk. Before we go on to WSIB and a few issues there for legal liability and risk management, do we have any questions?
Norm, yeah, that was good. You hit a lot of good points there. Some of the ones that I noticed there was the importance of the general duty clause, and that the employers are required to test workers for compliance, basically the pre-screening, and also that pre-screening you recommended that the thermal testing be part of it. I guess that's not really a legal recommendation, but it's not really a legal requirement. But as you said, it was more an objective, more subjective than it is objective. Can you just sort of speak on that, elaborate on that?
Sure. What a thermometer, any type of screen, gun thermometer, et cetera, usually non-invasive or non-touching a worker does is gives you objective measurements. You don't get that with the screening questions. Now, you can't turn every supervisor when they're letting people into a construction site to assess somebody as to whether they're telling the truth or not. And you've got a whole crew coming in every day. But what you can do, and it takes mere seconds, is to have them stand in front of a temperature screen. And will it guarantee 100% of the time to detect if a person has a fever, which is a clear sort of medium symptom of COVID? Well, no, it won't. But the temperature screening that NORCAT's promoted, as well as the temperature guns, are reliable of 85 or 90% or higher. And if we're talking about a vaccine that's about at the same level, we've got to talk about the benefits plus the risk. We've done some legal research. We're not giving legal advice here in the presentation. I can't because I'm not retained by any particular client, but we're very comfortable in saying that the law, in our view, supports that right. Here's the problem. If you can do it, but you don't do it, are you failing to take every precaution reasonable? That's going to be up to a judge to decide. But I think if you're not going to implement using temperature screening as an access criteria, you've got to be able to answer the question, why didn't you? And so you need to look at it. You need to see how practical it is. You need to see the cost-benefit analysis of it. And then you have to make a decision. Because you may very well, if you're ever prosecuted, be asked by a Ministry of Labor lawyer or an inspector or a judge why you didn't. And I think you need a good answer for that. Okay.
On those questions there, I've heard the term active screening. The active screen, does that mean you actually physically have to ask them each day, or can you use an app?
Oh, no, you can use an app, and that's to some extent what is the standard now. What I meant by active is active and ongoing or daily. So yes, an app is perfectly legitimate, but again, it's only going to give you the information the worker's giving you, which again is their self-assessment and depends on their integrity. And hopefully there's a high level of that, a high level of consideration to co-workers. But sometimes people are difficult or desperate straits. So one of the examples I'm going to give you in a minute shows that. So why don't we go on?
Yeah, that leads on to that next question.
Compliance issues. Sorry?
Yeah, that leads on to the next question about the WSIB. You sort of brought into the requirement for an employer to report, and section 50, 52 too. The reporting requirements. I'm sure you'll speak now on the follow-up from there. Thank you.
All right, thank you. Sorry, there's a bit of a delay, I think, over my voice-over computer contact I've got here. So obviously, if someone gets ill, yes.
1 second there, Norm.
Just to remind everyone, we've got a Q&A feature at the bottom of your screen. And in between various sections that Norm's presenting, we'll stop and give people question to ask questions. If you put them through in the Q&A, Dan will ask the questions at the appropriate time.
All right, terrific. Thank you. So the Workplace Safety Insurance Board administers, as the regulator, the Workplace Safety Insurance Act. It's workers' compensation coverage. We are getting weekly calls from construction clients about the whole problem of, well, somebody thinks maybe they have COVID, they're not sure where they got it, they're off for 14 days. What do we do? Well, really going back to first principles, the trade-off for workers' compensation benefits in Ontario, going back to 1914, so well over a century now, is that it's a series of no-fault benefits to workers and their dependents if there's a death. And there has to be, though, evidence that it was a matter that caused the health consequence, in this case COVID-19, arising out of in the course of employment. That's not always easy. We know COVID is so transmittable. So if you get a complaint or a claim and you go to the WSIB website, they're going to say, when in doubt, report. My advice is a little bit different. My advice is, when in doubt, investigate. Because sometimes it's going to be clear it is work-related, or pretty clear it's not work-related. Sometimes you're not going to be able to know easily. So a valid WSIB claim based on a COVID-19 infection, which could result in a couple of weeks off of work, or obviously a lot worse, requires evidence of a significant contribution towards the cause of the illness. Doesn't necessarily have to be the only cause, but you need to actually investigate that, and that's not easy to do. It means talking to the worker, but talking to other people at the site and gathering the best evidence that can be made available from the worker, from their healthcare professionals. Now, when we have COVID claims, the WSIB has given some relief, so it's not a direct cost to you. It doesn't have a direct claim cost to you, but it's going to be paid through the system. And let's remember that it's employers that fund the system. So the other thing is that you don't want to deny worker benefits if they truly are entitled on the one hand. On the other hand, you don't want to encourage fraud. And I don't say fraud in the sense that maybe the person doesn't have COVID. They may very well have it, or they may actually die from COVID. But I'm saying fraud often is happening, or we're seeing this in a number of cases, where the exposure is well known to the individual or their family to come not from work, but from another known source, but they want it to be a workplace-related exposure for obvious financial reasons. So it's a tricky subject. It's one that, you don't talk about at a cocktail party or a virtual cocktail party, because it sounds like, gee, you're being hard on people who are getting COVID. That's not at all what I'm saying. What I'm saying is you still need for a COVID WSIB claim to have evidence that it was reliably or significantly a workplace exposure. Now, workers without symptoms are actually encouraged by the WSIB to file an exposure incident form. This doesn't necessarily translate into a claim, but there's a program called the Construction Exposure Incident form process, and that's a way to get on record that you were exposed and that there's follow-up medical problems, then that can be dealt with through a formal Form 7 claim. So WSIB takes the view, as I said, that if a worker believes they've contracted in the workplace, then they should tell their employer. They may not tell their employer, though. They may file a Form 6 themselves, or they may go to a healthcare professional, and that may be a Form 8 that gets filed. But if they talk to the employer shouldn't just say, okay, I guess if you think you've got it, we're going to file a Form 7. You should encourage that worker to go get tested, to self-isolate, and to provide you with the results. So there's a management and a time kind of expenditure that you've got to invest when you've got a potential claim. Then you also have to look at the possibility of spread. So you've got to talk to and encourage other workers. And if you've got a positive test and that person was on a crew, you're going to have everybody else test positive. So as you can see, there's quite a knock-on effect or an unintended consequence effect to this whole idea of somebody claiming and you allowing, through filing a Form 7, a COVID-19 positive infection without actually knowing if they did. So you have to follow up. You can't guess. And there's too many implications for business continuity, for the risk to other people, for you to simply say, oh, well, if he said he had COVID, he must have COVID. We're in the flu season. Not everybody gets the flu shot. People get sick, they get a cold. The symptoms overlap with, but are different than COVID. So it's very important to really follow up and get objective medical evidence for a confirmation of a COVID claim before you accept it. Now, we know from the WSIB, and I've got the website linked below, over 7,200 cases have been allowed. A remarkably high number, this is remarkable in my experience, have been denied, and some are still pending. WSIB now is contacting workers 2 to 5 days to adjudicate in their claims, to get more information. And what the construction industry should pay attention to here is that it's not one of the hot spots. So although there have been cases and claims, and in several cases that I'm aware of, tragically, workers have died from COVID, likely from a workplace exposure, that is not where most deaths are coming from or claims for WSIB are coming from. Nursing, residential care sectors, as we might expect, agricultural, as per the example I gave earlier, and then hospitals. So construction, by and large, has done a good job, and simply because you get a worker or have concerns and have evidence that there may be a WSIB claim doesn't mean that you just accept it. You manage it properly, both for the process of filing the claim properly, but also for making sure it doesn't spread in your workplace. Best practices for managing claims: a thorough and comprehensive internal investigation. If the person can work without wage loss in an isolated setting, i.e. working from home, it's not often the case in construction, you may want to consider it. So those are some of the thoughts and recommendations for managing claims. I don't know if there's any specific questions that people have. There is a new return to work policy that was recently enacted less than a month ago by the board for construction. You may want to look at that. If you need some legal advice, let me know. Myself or one of our paralegals can help you. We are seeing, I got to be honest with you, we are seeing a number of, I think, growing frivolous and even, stress-based but not stressed WSIB claims. What I take from that is not that people are getting more dishonest or more tending towards fraud in WSIB areas, but more people are just stressed and worn out from COVID. There's COVID fatigue everywhere, including workers on construction sites. And so I think people are trying to find a way to get paid and not work. And I won't comment on whether some government programs have motivated people towards that direction, hopefully not. But that's what's more important to manage claims well, not just COVID related, but old WSIB claims, because we're seeing a real spike in them. And a lot of them, I think, are laced with, COVID fatigue, and that turns sometimes into WSIB fraud. So you want to not get hit with those, because that could affect your spirits rating, especially if they're not COVID, your cost. And this is not a time when we're in a recession where you want to be loose in managing your workers' compensation claims and costs. So are there any workers' compensation issues that have come up?
Yeah, so just, Norm, we do have a couple of questions. Got an anonymous, I'm not sure who it was that asked the question. It must be on one of the phone calls, but it just clarification of a worker contacts COVID from a source outside of work, comes to the workplace. Does the Ministry of Labor need to be notified? And if not, if no one has come in close contact with the infected worker, does the Ministry of Labor need to be notified? So
that's a good question, because if the evidence supports everything you've said and there's been no transmission of COVID to another worker, the short answer is no. 52.2 will only require a notification of the Ministry of Labor of an occupational illness when there has been transmission of an occupational illness to a worker at a workplace. Now, how you kind of deal with that is a challenge, because, if a worker comes to the workplace, have you isolated them with COVID? Have you isolated them quickly enough? And have you removed them quickly enough? A good way to think about some of this, to cut through the complexity and the myriad of examples we could talk about, is to think about COVID-19 as a hazard that is brought to the workplace by the worker. And the worker doesn't intend, I'm sure, to transmit or communicate the disease to another worker. But in effect, when you stop the worker from coming into the workplace with a disease, you stop the hazard from coming into the workplace. So that's why access control is so critical. And as COVID fatigue and the pandemic drags on week after week, month after month, it's easy to be, of the view that, oh, well, the crew that I'm trying to screen here, they were healthy yesterday or healthy last week, so I'm sure they're healthy now. That's where you cannot let your guard down, because then you get the health and safety reporting issue you've just raised, as well as workers' comp costs and other perhaps compliance issues. Any other questions?
Yeah, it comes in a question that Carlos brought up regarding the obligation of an employer if a worker is suspected of being sick. They pass the pre-screening and their temperature checks, but they're coughing and sneezing and hacking on the project. What's the obligation of the employer there?
Right. I mean, I would recommend in this current situation that you ask the worker to go home and stay home until A, they're symptom free, or B, they get a COVID test. And if this is just a head cold that lasts for a week, but they can manage it with some over-the-counter medication, and they can prove that, well, look, I got my COVID test and I don't have COVID, I've got a head cold. I don't think, during the full 4 to 6 months of winter that we have in Ontario, that one should not expect to still have a risk of a head cold. That is different than COVID. COVID is primarily a respiratory disease, not a sinus congestion or head cold, although some of the symptoms clearly overlap. So, but because the consequences of COVID infection are so potentially severe and potentially fatal, I think you need to be careful. You need to send the person home and get the verification that they
can
have a COVID test. Or, oh, absolutely. Your duty as an employer to take every precaution reasonable for the safety of every worker will trump any bit of sensitivity, any bit of union griping. Well, gee, he just had a head cold. When you get that call from a business agent, you can say, well, wait a second, are you saying that you can guarantee me that he didn't have COVID without a test? Well, of course they'll say no. So you'll get into some push and pull in some of these examples on the edges. But if the guiding, light or direction you take is that, no, we have to keep people safe, and we're not going to take unreasonable risk. If there is any symptom that potentially could overlap with COVID symptoms, then you have to prove you don't have COVID, period. Or you're off for 2 weeks without pay. And unfortunately, you're going to get pushed back, and you're going to have to manage case by case. But the risk of not taking that step is a risk of violating the Occupational Health and Safety Act, but perhaps more importantly, morally, it's exposing another worker or a whole crew to COVID. They take it home and somebody in their family, expires or dies. I mean, it's just not acceptable to play games around the edges of these cases. Clear, firm rules will get you where you want to go. And there will all be outliers or, sort of aberrant cases or, unusual cases you may have to deal with around the edges. But by and large, that's going to be the best advice to strictly and fairly enforce your COVID policy.
Yeah, I'm glad you answered that because that came up in one of our training courses. We were doing some supervisory training and that exact question came up as can an employer make it a requirement to ask for a COVID test prior to the worker returning to work if there's a suspected COVID. So thank you.
Right. It's almost, and I don't want to compare it completely. It's almost to having a worker smell like alcohol and you ask them to say, oh no, I just, I had a beer at lunch, but I'm not intoxicated. Well, that's where zero tolerance says, no, sorry, you're not here anymore. If a worker smells like marijuana and it's really hard to tell if somebody's stoned or not, and the police are doing that every day on our roads now with the new rules under the criminal code, zero tolerance. You're not going to take the chance. And if you have to deal with a grievance, it's unlikely you will, but if you have to, you have to. Better take that risk of legal consequence than the greater legal risk of the health and safety non-compliance, in my opinion. But each case has to be assessed individually.
Thanks, Norm. Just one last comment. One last comment from Ian Cunningham. Just to add some thoughts on Bill 238. I'm not familiar with the bill myself, unfortunately, but maybe you can speak on that.
Well, that is a bill, as I recall, that talks about relieving companies and entities from liability if there's a COVID test. That's probably a 1-hour presentation. You get a lawyer going, he'll just go. But I'm actually going to do a presentation in February for the Ontario. Who are they? The OHSA. I know them by acronyms. Sorry. And we're going to talk about officer and director liability, and that legislation is important for us to talk about, but it's a little more complicated than just a short answer. So to talk about the bill, that's an hour. But the thing that contractors should know is that WSIB protects you from civil lawsuits, and it protects officers and directors as well. But nothing in the legislation that Ian wants to know more about actually precludes the Ministry of Labor from regulatory enforcement, or, as we've heard about in Quebec, there's going to be some criminal negligence causing death, criminal charges laid in some of the long-term care homes. That's been announced. Whether they go through with the charges, who knows, but there are criminal investigations going on. So that legislation won't protect you from the Ministry of Labor or the police if you're that negligent about how you're managing COVID. It may affect retail outlets who have, somebody come in, they're buying something, they're allowed to be open, and they get COVID from another clerk or another shopper. That's generally where that legislation is leading to. But if you're covered by workers' compensation, then it's not really even an issue. There is no civil liability risk for businesses in the construction industry. But if Ian wants to give me a call or chat more, be delighted, Ian. Let me know if I've missed the mark on your question or.
It's a big issue.
Norm, one more question. One of our members came forward to us and they've received a lost time injury on a COVID claim. I talked to the board about this. They said it relates to having an employer of record for return to work. But there's a surprise because now COVID claims are appearing on the employer's record. Can you comment on that?
Well, yeah, I mean, I agree, David, that it's an issue and it's going to become a bigger issue. It's going to affect your workers' compensation costs. And so I think you need to go back to first principles that I covered a little bit earlier, and you have to investigate very carefully these claims. A lot of people just would like to continue to stay home and not work and get paid by somebody. They'd prefer it be WSIB because it's going to be more money than, than unemployment insurance. So there's an economic motive, like it's almost rational for workers to commit fraud. And that's unfortunately how the system's set up. So you need to be scrutinizing this. And especially because there's a lot of COVID fatigue and a lot of COVID frustration out there, and maybe a lot of good Netflix series to catch up on, people fall into temptation. So you've really got to be careful about managing it. And if you've got an excellent access program and protocol, and if you've got good supervision on your projects and you're managing it well, you're likely going to prevent people from coming onto the job site with the hazard of having a COVID infection, and likely also, if somebody gets through that access control and screening, to spread it to others. That's why being rigorous on your safety procedures is so critical, because then it also helps you to argue, if you have to appeal a claim like that, that look, it's so unlikely, and we have medical support for the position we've taken, that we need to look more carefully at the claim, and either the board or you or both investigated. And I think we're going to find a lot of people are getting COVID from non-workplace transmission, but trying to claim it is workplace transmission because they might be quite sick, and or they may want to just have some time off. But either is not appropriate. If it's not, arising out of the course of employment, the COVID transmission, and there's proof of it, then it's not a proper claim. Okay.
Thank you.
So let's go to just a few thoughts about labor law. This is a whole other big area. Your collective agreement may or may not have safety requirements, may or may not deal with leaves if people are sick. You need to start with, of course, the collective agreement to see what the relationship is. Most collective agreements do not require or allow an employer to pass rules about an infectious disease. No one really had this on their radar screen last time bargaining came up. But under a management rights clause, there is, under the KVB test, a right for management and employers, in fact, a duty under the Occupational Health and Safety Act, to pass reasonable rules and enforce them. So all of these obligations that you have under the Occupational Health and Safety Act and legal risk, remember, unions don't have them. Unions don't have any duties under Part 3 of the Occupational Health and Safety Act. As much as the union may want to tell you how to run safety in your program, they have no accountability. And so you need to respect the union side members in a joint health and safety committee. They have an important advisory role, especially in communicating with workers on the job. But remember that you're going to be the one holding the bag, so to speak, as the employer, not the union, when there's accountability. So you need to have rigorous enforcement of your COVID policy and safe work procedures. And you have that right under collective agreements under management rights clauses. That means training and enforcing this through your supervision. And you might have work refusals. It's one of the points on the slide. Section 43 of the Act, as you probably know from a previous slide in the presentation, gives every worker in the province, including construction workers, a right to refuse to do work they believe subjectively to be unsafe. That triggers a requirement for the supervisor, the worker, Joint Health and Safety Committee members to investigate. If you can't resolve it and the worker continues to want to refuse, you can't fire them under a reasonable rule under the collective agreement. You have to call in the Ministry of Labor. The Ministry of Labor may do this remotely, and there's a whole number to call and get the Ministry of Labor out to assess the situation. You can technically, in that type of a work refusal, have a replacement worker, but you have to go through the hoop of having a union member present when you tell the replacement worker that the first worker who's refusing did so because of a COVID-related exposure issue. So it gets complicated. Ministry of Labor generally has been resolving work refusals in favor of employers. So that says two good things. One, employers are taking COVID precautions seriously and enforcing them. Two, the Ministry of Labor is taking a fairly objective and professional view, which I think they are by and large of these work refusals. So if the work refusal is driven by fear, paranoia, COVID fatigue, that's not a proper basis. There has to be an objective safety failure in the COVID policy and access requirement to justify that. There may be a temptation for employers to say, hey, this is a bad worker, I'm going to lay them off or fire them because they exercise the right to refuse to do unsafe work. I'd go back to the farm case we talked about a few minutes ago and recommend you not do that unless you have a really disruptive repeat offender who is just giving, everybody a bit of a hard time. And, you may want to talk to the union steward about that, or you may just want to progressively warn and then suspend, and then that's it. You're gone, because you keep raising concerns, you can say, that cause you and other people not to work that are ill-founded. But you can't do that the first time around. You've got to be patient. You've got to build up a record and take the discipline in a progressive manner, according to arbitrations and the labor board dealing with that. The other points, and there's many of them really to expand on in this slide, but I want to do so briefly, is that I've been involved in several cases now where one worker, they may be from outside of the jurisdiction in the one example I'm thinking of, but one worker says, I don't think this is safe, and then a whole bunch of other workers sort of pile on. The thing to remember about Section 43 of the Occupational Health and Safety Act, it's an individual right to refuse. Each individual who says, I'm not going to work because this is unsafe, and we're talking about COVID, so there's a COVID risk here, they each individually have to come to that assessment. If they don't, and there's a group or a mass workout, it could very well be that you have a staged illegal or unlawful strike. And unions aren't generally promoting this. They understand that in most cases, at least, the Section 43 under the Occupational Health and Safety Act is an individual right to be exercised individually. And it's not a right to, abuse, on the job stress or to walk off for an unrelated issue. But it really is something that, as things go on, as maybe cases spike or there's an outbreak at a project, it's going to increase the anxiety, the worker stress. And that's, I think, what I've seen driving more bad or poor judgments on the part of workers about exercising rights to refuse. And then the union feels, in many cases, they have to back them up when, in fact, they don't. But the duty of fair representation really only goes so far for a union. They can still make a judgment call. But trying to calm things down, try to have your supervisors coach and encourage people to follow the rules and to take care and concern for the other workers is really a key part of working together through this and avoiding those labor relations clashes. Any questions about labor law? This could balloon as well, so we've only got time for a couple, but I'm happy to try and do my best to answer them.
I didn't see anything specifically on the labor law issues there. Yes, Phil. No, we didn't have any questions on labor law.
Okay, sorry. So let's touch on employment law issues. So if you're not governed by a union, or if you have staff at the office or senior staff at a project that are not unionized, employment law still applies, but a little differently to construction. And this is a very brief overview primer. So if you're hiring new people, there's been a lot of cases in the last 2 years, like almost an avalanche of cases about whether you can have a termination clause in an employment contract that limits your termination notice obligations to the employment standards minimum. Now, this gets more complicated in construction because, as we'll talk about on the next slide, there's exemptions under the regulation, under the Employment Standards Act, so it doesn't apply to construction. But if we're talking about management personnel and your office personnel, I think you want to look very carefully at 2 or 3 kind of solutions to minimizing the risk of wrongful dismissal lawsuits. If you have to downsize, if things, continue through a COVID and post-COVID recession, just to minimize the risk to the organization so the organization doesn't fail or doesn't have financial distress. So have a properly drafted employment contract. It can be in the form of a letter. I prefer that in many cases, unless it's a very complicated relationship or very senior executive. So a letter is and can be a contract that you get a sign back of. You can set out the terms and conditions, salary, benefits, start date, but you also want to avoid risks of constructive dismissal. So you want to give expansive and broad description to the duties so that you don't have somebody saying, hey, I was hired as the controller for this construction company, and now you have me dealing with safety or COVID policies. You want to give yourself the flexibility as management in your contract so that people don't say, hey, that's not my job. In other words, you don't want them to go union. So that's critical. The other issue is, can you limit the amount of notice you pay? And the answer is yes. Certainly the Court of Appeal has said that. And then every second clause they take a look at, they strike it down. You want to look at drafting a simple but clear clause that gets the point across that when you're let go, we're going to limit, we're going to pre-agree, we're going to define in advance what you get. And that's tricky, but it can be done, and we're happy to help clients do that. The other way to look at your exposure to risk is to say, well, this is a fixed term contract for 1 year, for 2 years. The maximum is 9 years. Nobody really does it beyond a year or two. But if you have somebody you're hiring for a fixed period of time, you can always renew that contract. But the notice is given to the worker in the fixed term contract on the day they sign it, the day they're going to be terminated or it's going to end. So fixed term contracts have to be clear and simple in terms of the expectations of both the worker and the employer, but it's another drafting technique or tool that you can think about for new non-union employees. Now, none of those considerations are easily applicable to current non-union employees unless you give a change of position, a change in value, or lawyers call it consideration, usually a raise. So if you give somebody a raise, you can say, well, look, your income or your compensation is going up, but we're going to contain and address the risk of if the relationship doesn't succeed, if it fails at some point. And so even if it's a not cause termination, we're going to limit the compensation you're going to get. We've made it very simple, very clear. If you have any questions, you can talk to a lawyer if you want, but here's the deal. The new clause limiting our exposure, if we ever have to let you go, is in exchange for your increase in salary. I don't see any point about being complicated, sneaky, or not transparent about what you're trying to achieve. You're doing it not because you hope to let the person go for not cause in the future, but because in COVID, with so much uncertainty, if you're hiring new people, it's a good strategy to control and limit your liability. The other issue is the just cause provisions of the Employment Standards Act are different than the common law definition of just cause, so we get into all sorts of complications. So don't want to belabor this point because we're kind of getting tight for time. Let's go on to a couple more that I want to make. If you're going to be disciplining employees, there's 7 points here. This is not the definitive list or the, couldn't add more to it or couldn't make the list shorter list. These are common sense, practical decisions that both arbitrators in the union setting and judges in a wrongful dismissal non-union setting will take into account. And so you need to treat people with respect. You need to make sure you're not discriminating on human rights grounds, that you're treating people fairly. But if you're going to discipline for a COVID-related issue, I think it's really going to test how effective your program was. So if you've got outlier cases or problems, it's really going to say, did we set a clear standard? Did we communicate it? And are we now enforcing it? Now, under the Employment Standards Act, as I briefly mentioned, Regulation 288 of 2001 carves out exemptions for severance pay and notice pay or termination pay, as we call it. Simply because that's done, though, doesn't mean a construction supervisor might not be able to sue for wrongful dismissal or reasonable notice. That's where you want that contract that I was talking about as a preventative measure. So common law reasonable notice is what people sue for when they sue for wrongful dismissal. We've got lots of cases of wrongful dismissal going on. Some are foolish, some are legitimate. And there is a very rule of thumb approach. There's a whole raft of cases, and the more similar cases will be influencing a judge if you go to trial on this issue of precedent. But precedent's an easy thing to get around if you don't treat somebody well, or if the employee has not treated you well, then vice versa, they can have a diminished entitlement in the nuance of the whole assessment of reasonable notice. What we can say in terms of recommendations is termination for just cause is difficult, but not impossible. I'm going to tell you about a quick example in a moment. employees have duty to mitigate their losses. So if you're a construction superintendent and you've been let go, well, you have to go and try and find another job before you can legitimately claim and sue for wrongful dismissal. And if you do settle a case, please get a full and final release. A handshake is a nice thing, perhaps not in COVID, but it's not going to stand up in court. A full and final release will. So kind of lastly on that subject, just one more thing and then we'll go to questions, and then contact information. There have been several cases, and I'm sure there's many more in the system and several I'm dealing with, where both in an arbitration union setting and in a wrongful dismissal non-union setting, people have been let go. People are saying, gee, I'm out of work and I can't get another job because of COVID. That may or may not be true. And depending on the kind of work they're doing, we know that some employers are doing well, and the construction industry generally is doing well. So don't just accept that, gee, if you have to let somebody go, even if it's not for cause, that you're going to be paying up to 24 months notice, which is the de facto, unless exceptional circumstances, notice you have to pay for a long-term employee. But it's very legitimate for an employer to say, look, where's your proof that you tried to find another job? And maybe we're going to help you try to find another job on the way out. So the duty to mitigate, even in a non-cause setting, is a major area where your management side labor and employment lawyer needs to give you advice and proper representation, because it can significantly reduce your risk of exposure. Anyway, covered a lot of ground. Sorry if I've sounded like a lawyer. I confess I am. That's where I can be reached if you want to get some legal advice. And if there's any questions, if we have time, I'm happy to try and answer them. Thank you.
Yeah, I noticed there's a couple of questions that Dan can get to. If I could just lead off. So the big news today is the vaccine. And the first vaccine in Ontario occurred a couple of hours ago, which is great. We have some reason to believe by sometime next year, the vaccines may be available to a majority of the working population. And so when that happens, is it reasonable for an employer to make it a condition of employment that their worker receive the vaccine?
If you get 3 labor lawyers, David, and audience in a room, ask that question, you will definitely get 4 opinions. So I can't give specific legal advice, but what I can do is say 3 things for certain. Number 1, it appears, at least to the present time, that federal and provincial governments are not going to make vaccination mandatory. Now, we make vaccinations for children mandatory in the schools, and there are very limited religious and medical exemptions for that. So the government could have said, look, thousands of people have died in Canada. Over almost 1.5 million people have died worldwide. This is terrible. This is worse than seat belts not being worn. We mandate seat belts in a car, so we're going to mandate this. It appears they're not going in that direction. So that's the first key point. So, and this is the story with a lot of the issues of the pandemic, you're kind of up to first principles of law, and your best practice has to be what you as an employer impose on your workforce, on your workplace, rather than look for clear, direct help from the government. Second point, there are cases going back to the H1N1 pandemic, and it was a pandemic. It was a highly lethal virus, but not as communicable as COVID-19. There were a number of cases in the healthcare sector where arbitrators and judges had to deal with the issue of, can a hospital say to a nurse or a doctor, anyone really, you have to be vaccinated or you have to mask at all times that you're at the workplace. By and large, those rules have been upheld. So if we look to that as a guide to where courts and arbitrators have accepted a practice, we see that you can impose a rule of either you get the vaccination or you take other acceptable precautionary measures. So that's going to be, I think, where a lot of healthcare providers, hospitals, long-term care homes, et cetera, are probably going to land. However, I think because of the number of deaths from COVID and because of its huge knock-on effect to the older and the more vulnerable population for which the employer has not direct control over, but it has a broader moral awareness and obligation to, there is an argument to be made, both under the Occupational Health and Safety Act and Section 217(1) of the Criminal Code, that you can impose it as a reasonable requirement and a reasonable rule at a construction site, let's say, with two exceptions. One, though it's not likely to be vigorously pursued and will be a very small percentage of your workforce, is a religious objection. I won't go into that, but that's been sort of carved out in some of the blood transfusion cases, and ultimately the courts intervene on the part of a minor when a religious group says we don't want blood transfusions, even though it may save the life. That's a more intense and unique example, so I don't think the courts will go quite that far. So there likely still will be a possibility, I would say, of a religious exemption from a vaccine. The more significant exemption is the fact that there is a very small portion of the population that, from what I've been reading and what the medical experts have said, are actually highly allergic to vaccines of any kind, and likely the COVID vaccine as well. There have been several examples in the test that you may have read about, and there have been several examples in the United Kingdom already in the last week of severe allergic reaction to the vaccine. So as best one can determine and procure medical support for that exemption, then I would think you have to follow the vaccine rule must take that into account as well. So lawyers often spend more time talking about the exceptions than the rules, or the exemptions than the rules, but is there a strong occupational health and safety and West Ray Bill criminal standard support for mandatory vaccination? Absolutely. Will it be provocative and cause controversy? Probably. So, you've either probably got to go with a modified rule, and these are just preliminary thoughts on the matter, of vaccinate or mask up for everything. And that's going to include returning to construction head offices as well as construction projects. Or a more aggressive rule, which says, if it's available, you have to take it, and we want proof of vaccination, or you are either A, going to have to mask up, or B, you're actually not allowed back in the workplace. And then you get the question, well, can you in an office setting, as an employee, say, I never want to vaccinate, I don't want to come in with a mask, and I want you forever to hire me working from home? I don't think, that's already been debated among employment lawyers. I don't think that's going to fly in the long term once we're truly free and clear and out of the pandemic. So I think the issues are emerging. You can find no more hits in Google on employment law issues than the issue or the question David's asked. And I think perhaps we should put that on the agenda for a topic next year. And it would be interesting to get a very qualified doctor, as well as a lawyer and sort of a practical healthcare worker, to comment on the issue. I think there will be leadership in the area. I'm not sure what organizations will, if it'll be healthcare where the vaccines are coming in first. I assume it will be. But I think because healthcare workers and doctors and long-term care homes, they've suffered so much, as we saw in the statistics, the fatalities and the severe reactions. I will not be surprised, and I think I'll be somewhat heartened if there's leadership that says you have to get vaccinated unless you fit into one of the very, very narrow exemptions where it's acceptable to us as your employer that you would not get it. Because if it's available, if it's efficacious, 90% or more, and remember, the flu vaccine any given year is anywhere from 30 to about 60% efficacious. So you've got a vaccine responding to the virus that's better than the annual flu vaccine. So why wouldn't you require people to have it unless there's one of the minor exemptions or exceptions to that general rule? So tricky subject. That is not legal advice. That is off the top, quick answer and guidance only. And we'd be happy to help you and your organization work with their vaccine policy.
Thank you.
Thank you. Thank you. Thank you, Norm. I just got a couple of quick questions we had from some of our guests that are online here regarding reporting. Most workers travel together in the same vehicle. We have, if one of those workers is tested for COVID and is transmitted to another worker during their travel time to get to work, is it reportable to the Ministry of Labor?
I assume in the question you meant they were tested and they came back positive. So assuming that's the case and you know for certain they travel together, yes. All the current health guidelines are not ambiguous. All have to self-isolate, or the proper word is actually quarantine for 14 days. And they are obliged, not the employer, to notify the regional public health unit. It's just like when you come from a flight overseas, which you're still landing, you have to quarantine for 14 days. There's no option. Other jurisdictions, as you may know, Alberta is looking at a shorter period for quarantine. New York State already has a 4-day quarantine if you pre-test and post-test your travel coming into the state. I think that's a more sensible rule to follow than the Ontario and the general Canadian rule. Hopefully, we're going to move to a more sensible approach where if you travel, or if in your example, Dan, you test positive, then you can go out and test the other 3, and if they test negative, then they can come back to work. But currently, the public health rule is they're all quarantined for 14 days.
Yeah, I think the question was regarding the notification to the Ministry of Labor, whether it's deemed as transferable at work, the fact that one worker transferred the COVID to the other worker and they were both traveling in the same vehicle together, and they were the only case.
Oh, I see. Yeah, no, there's a nuance to that I didn't pick up on first time around. So in other words, if the place of transmission is in the traveling to and from work, is that considered an occupational illness? The short answer is going to be no, unless you're in a remote work location where you're paying them in effect to travel. As soon as somebody's off your site, they're off your site. If they, stop for a beer on the way home, assuming you can get one, and then they have an accident, that's not your problem. That's not a compensable claim. So similarly, if they're coughing and wheezing all over each other in the drive home, and they choose to do that, and that's the provable source of transmission, that is not, in my opinion, a workplace transmission where 52.2 gets reported. However, why they're traveling together, if somebody's got COVID or somebody's got COVID symptoms, I've got to ask, are they using their common sense? But that's a separate subject.
Well, I guess similar question on the same vein as a general contractor. If a subcontractor tests positive and one of their subs is test positive also, does it fall on the general contractor or the employer of the subcontractor?
When you say does it fall on them, if you mean do they have
Notifying.
to report it?
Yeah,
The notification or reporting is the employer's obligation under 52.2. I mean, you may want to, if you're the general, if you're the constructor, remind people of that, and from time to time, look, you've got to report this. We want a good relationship with everybody. We want a good relationship with the Ministry of Labor. This is a reportable duty. Don't play games with us. Don't hide stuff. If you notify the Ministry of Labor, you must notify us as well. You may want that in your contract documents too. I would always recommend that you are informed as the constructor, the general, everything that's being communicated by any subtrade to WSIB and or the Ministry of Labor. But yeah, it's the direct employer's obligation.
So one last question from Carlos regarding mandatory mask policies. For a worker with a medical exemption, a legal requirement, is there human rights concerns if you deny them access to your site without a mask?
Yeah, people get really wound up about human rights and all of that stuff. You cannot discriminate under Section 5 of the Human Rights Code against a worker for a prohibited ground of discrimination. Disability, if they have a medical disability or condition that prevents them from asking, say, a breathing problem like asthma, that is an absolute requirement. You have to not discriminate against it. However, you can't expose that person to other people or vice versa in the middle of a pandemic. So you have to accommodate the worker who cannot wear the mask. Let's accept that. That's his medical restriction because of his underlying disability. They cannot wear the mask. You can't expose that person. They don't get a free pass to be foolish or to take risks or to transmit the virus to someone else. So you have to look at it from the overarching health and safety perspective while at the same time accommodating. So you have to accommodate to the point of undue hardship. Undue hardship would mean killing the worker. Undue hardship would mean killing a worker, i.e. the transmission of a lethal virus. So you will never have, in my opinion, a case where a worker says, well, I have a medical condition, I cannot wear a mask, but I get to work beside other people within a foot of them on the construction site because of my medical exemption. That's just foolishness. So you have to accommodate that worker. So the question becomes, can you find a job for them to do that's away 2 meters or more from someone else, like throughout their whole workday? And if you can, great. And you've got to look hard, great. Do you have to create a job for them? Generally, the case law is no. So you want to totally respect people with a medical condition, but that might take them out of your workforce because they can't otherwise meet the essential duties of the job. So you want to protect everybody, even or especially people with a medical condition. But if they can't wear a mask and you say, fine, you may not be able to have them work with you. And that's not because you're discriminating against them. It's because you care about them and you want to make sure they're safe and not a risk to other people if they're carrying the virus.
Thank you, Norm. Thanks. That was very informative. And again, yes, just the tip of the iceberg for some of the stuff we got coming up with vaccinations in the new year. So I'd like to thank you very much for your informative presentation. I'm sure it was very well received. I'll just have David just speak a little bit about the joining the League of Champions and our website, and then I'll close off with the last following words. There, go ahead, David.
Thanks, Dan, and thanks for everybody who joined us today. As mentioned, this program was recorded, and Judith will be putting it up on our new League of Champions website by tomorrow. Please go to the website. You'll see it's being totally revamped, totally reorganized. In particular, the all 11, soon to be 12 webinars will all be there for easy access to you. So I encourage you to go and have a look at that. I'd like to thank you for joining us this year for these presentations. And thank you for all the good work the League members have been doing in health and safety. Just as an aside, this has been a particularly tough week for construction health and safety. There's been a number of terrible, tragic accidents this week, the most recent just in the last few hours. And we need to remind everybody, we're focused on COVID, and COVID's very important, but it's everything. It's all the hazards that are out there. And it's too easy to forget about all the other stuff we spent years focused on when you're focused on COVID, but we can't afford to do that. We've got to keep our workers safe. As members of the League of Champions, we're all dedicated to keep our workers safe, but we have to stay on top of that. We have to continue to remind ourselves. So thank you everyone for your dedication, and thank you for joining us today.
Thank you, David. That's exactly my point there too, about the importance of staying safe. Condolences to the families in London and across Ontario with the fatalities that have occurred in the last week. And again, we have to, it's not only the COVID, but it's actually the other challenges we have on construction projects of staying safe and keeping our focus. So with that, I'd like to wish everybody a very Merry Christmas and all the best in the new years. And we'll hope to see you again in 2020. So all the best.
Thank you very much, Norm.
Yeah. Thank you,
Norm.
Norm.
Very much.
Thank you, and all the best to you.
Happy holidays, everybody.
Happy holidays, everyone. Yeah. Thank you, everybody, for your participation.